We all know what theft looks like when we see it. Your car's not where you left it, and you later discover it's been wrapped around a lamppost by a joyrider. But actually, that's not theft. But you can be guilty of stealing your own car. Confused? Well, stay with me. I'm Barrister Daniel Barnett, and in this video, I'll be explaining what makes something theft and what doesn't. You're browsing the fine wines in a shop, but you don't like the look of the prices. You slip a bottle under your arm and walk out without paying. At what point does this become theft? When you pick up the bottle? When you leave the premises? Or when you drink it? Or perhaps you haven't committed theft at all? Well, to answer the question, we need to delve down into the definition set out in the Theft Act 1968, which states that a person commits an offence when they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it. Or put more simply, it's theft when you dishonestly take someone's property and don't give it back. But lurking in the formal wording are a host of surprises, which is why we need to break this down. Property is the easy bit. Property is what you'd imagine, tangible objects like bottles of wine. But you can't steal land, you can't steal wild flowers, wild fruit or mushrooms, unless you intend to sell them. Information and ideas can't be stolen, and you can't steal services. Those are covered by copyright law and fraud law. You can steal travel passes by reselling them, and you can steal illegal drugs. A charge of theft requires the property to belong to another. Back to the wine. That obviously belonged to the shop, but it's not always quite so clear. In law, belonging means someone has possession or control of the property or a right to it. So if you take your car for repairs, the garage mechanic acquires rights to the car through the work they've done. If you dishonestly take your car away without paying, you could be found guilty of stealing your own car, as the Court of Appeal ruled in a case called Turner. And sometimes people forget that lost property is owned by someone else. That includes golf balls at the bottom of the course lake. In a case called Rostron, it was ruled the lost balls were still owned by the golf club. What about if your boss accidentally overpays you, or your bank wrongly credits your account? Sadly, Monopoly's community chest, banking error in your favour, doesn't apply. In Section 5.4 of the Theft Act 1968, there's an obligation to give back property received by mistake. Be warned, if you don't, it could be theft. Appropriation is something of a shapeshifter. Taking property is the most common form. That's what happened to the wine. But even swapping price labels would count, because appropriation is the assumption of the rights of the owner, and by swapping labels you're assuming the shop's right to set the price. Destroying property or offering it to sale also counts, even just retaining it. So failure to return a library book, if done deliberately, is appropriation and could be theft. Pawning something with the intention of returning it later would also amount to appropriation, because there's a chance it might not be recovered. An intention to permanently deprive, great split infinitive, is what distinguishes theft from borrowing. It's this part of the offence which means joyriders are unlikely to be prosecuted for theft, because proving an intention to permanently deprive the owner can be tricky. Instead, joyriders tend to be charged with the separate offence of taking without consent, known as twocking, an offence which was enacted to get around this problem. But if you borrow an item and intentionally reduce its value, it's still theft. Returning theatre tickets after the show amounts to deprivation of value, even though the physical property, the ticket, has been returned. And a final point. The offence of theft isn't complete until we've dealt with what prosecutors call the mens rea, the guilty mind. Remember the wine bottle under your arm that you walked off with? Well, there's still hope, because theft has to be dishonest. That means if you genuinely forgot to pay, then you haven't stolen the wine. That was the defence of TV host Richard Madeley nearly 30 years ago, who was found not guilty of stealing wine from a supermarket after he placed it on his trolley but failed to declare it at the till. His explanation that it was a memory lapse and that it was a genuine mistake was accepted. The prosecutors were unable to prove otherwise, so his explanation was accepted by the court, which meant he hadn't been dishonest, which meant he wasn't guilty of theft. Section 2 of the Theft Act 1968 lists 3 specific circumstances when taking property would not be dishonest. Firstly, if a person honestly believes they have a legal right to the property. This would cover taking a coat which you thought was yours, or someone might claim they honestly believed they were allowed to take items from a skip. Even though they'd be mistaken, their honest belief would provide a defence. Secondly, if someone believes they'd have the owner's consent, if the owner knew of the appropriation, that also provides a defence. So you might grab someone's fire extinguisher in an emergency, honestly believing they'd be okay with that. Or you might take a cigarette from a friend, believing consent would be forthcoming because they'd frequently offered you cigarettes in the past. Finally, it won't be considered dishonest if you believe the owner can't be located by taking reasonable steps. This might apply if you found a wallet with nothing inside to identify the owner. But finders keepers doesn't apply if the contents could reasonably lead you to the owner. In those circumstances, keeping the wallet would be theft. In all 3 cases, the belief has to be honest, but it doesn't have to be reasonable. Although, of course, if it is reasonable, it's more likely a magistrate or a jury will think it's honest. And finally, one fact you will almost certainly never need to know, but it's an interesting way to end. You can't steal a corpse. But this is the law, so obviously there's an exception. You can't steal a corpse unless skill and effort has been used to preserve the body. And if skill and effort's been used to preserve the body, it can be stolen. That's a case called Dudwood and Spence. Thanks so much for watching. Please do subscribe to this channel, and if you are interested in more criminal law explainer videos, there are some here. This is a video I think you might like, and these are some employment law videos. I'm Barrister Daniel Barnett. Bye bye.